When you enter our law office, you'll see a painting just above our front reception desk of Abraham Lincoln, General Grant, General Sherman, and Admiral Porter. This is a historical meeting held on the River Queen on March 28, 1865, where these four men discussed the terms of surrender they would not agree to give the Southern Confederacy. Why was this an issue? Because the Confederacy was asking to be treated as a defeated nation as if the secession had legally happened. General Grant, in particular, adamantly supported Lincoln's position that secession was not possible if law is something that, by its nature, can be enforced. Indeed, Lincoln had argued from the beginning that if any time someone does not like the law, they could simply separate themselves from that law's jurisdiction, then law itself is an illusion and can never be enforced. Power itself would always be the final arbiter. Not only that, but if secession were possible in any sense at all, then there would be no end to it. If a state could secede from the Union, then South Carolina could secede from the Confederacy, and Charleston County could secede from South Carolina, and the town of Rockville could secede from the county of Charleston, and any family could secede from the town of Rockville, and any atomized individual could secede from the family. The very idea of obligation necessary to the definition of law itself would be effectively meaningless. If, as a Southerner, you argued that secession is possible under the law, but only so far and no further, then the limit you were setting would be arbitrary and not based on reason. Indeed, everything would again ultimately be reduced to arbitrary will and power, which is the same as anarchy and might makes right. This meeting on the River Queen in 1865 was not the first and only instance in history where this argument has been made before, namely that the alleged legitimacy of leaving or splitting, once allowed, has no limit to it and will only continue endlessly to infinity in a reductionism ending in the denial of the very order and limits that make liberty possible in the first place. In this instance, it is worth understanding that Abraham Lincoln and General Grant were fighting for a philosophy of law that was entirely at odds with the legal philosophy that Jefferson Davis and General Lee were fighting for. Lincoln's legal philosophy suggests that authority is not the equivalent of will to power, that power is not everything, and that there is, in fact, something more and something higher than mere will and power. Thankfully, our legal system and our courts have inherited the legal philosophy of Lincoln and Grant, and not that of the Southern Confederacy. Of course, today, there are some particular demagogues and politicians who pretend to ignore this fact. This history is a compelling reason, following in the footsteps of Lincoln, for us to resist them. Meanwhile, our law firm, and all that we do for our clients, assumes this inheritance as a part of our foundational principles of law practice. This understanding has many practical applications, and we will explore them in time. For now, know this. Whenever you hire an attorney, you have two choices. Option 1. You could hire an attorney who doesn't make any distinction between the idea of revolution and the idea of secession and how that attorney interprets the Declaration of Independence. Option 2. You could hire an attorney who believes, as Lincoln did, that law, by its very nature, is a use of the sword of might that may not just be freely wielded or suddenly negated arbitrarily in a way that determines right, but for which must be exercised for right. No self-respecting and historically literate legal professional should ever forget this distinction, because it is between two competing points of view that have set the stage for some of the greatest contests of history.